Welcome. Welcome to A Taste of Justice. I am Professor Angela May Kupenda. For informational purposes, I'm a professor of law at Mississippi College School of Law. I've been teaching in law schools and business schools for about 30 years now. This series is for my students to give them a little something extra to help them review and think about the material we are covering, but it is for all of us to learn more about what the Constitution actually provides in terms of how the court has interpreted it. So today we're going to continue to look at the First Amendment. Specifically, we have been doing some shorts. I have some longer video clips addressing many topics related to the First Amendment, but we've been doing a few short reviews, and this one is on a category called fighting words. Now, our general rule is that pure speech is protected from content regulation by the government, unless the government meets a very high standard, or unless the speech is in an unprotected category. There are several unprotected categories of speech. We've talked about speech that advocates illegal action, defamation, and obscenity. So today we're going to give you a quick review of the fourth category of unprotected speech called fighting words. Now, in the text box below, I give you the links to some other video clips if you want to receive or you want to learn more about some of the references I'm making here. So what are fighting words? Well, if the speech falls in that category, government can regulate it more. So what are fighting words? Well, the court said in one case that fighting words are such words that would, as ordinary men know, cause a fight. Words that could cause an ordinary man, the court said, of common intelligence to fight back. So maybe we should think of fighting words as face-to-face words, or face-to-face provoking, or face-to-face insults that would likely cause a breach of peace. And as I said, there is a clip, I've indicated the link in the text box, that will walk you through each of the cases related to fighting words and related concepts, the cases we ordinarily teach in the First Amendment course at the law school. Now, if you recall, in an earlier clip, I told you about another category of unprotected speech called speech that advocates illegal action. So you may be saying, what is the difference in speech that advocates illegal action and fighting words? Well, if you're writing an answer, say, to a bar exam question, for those of you who are studying to become attorneys, or if for an essay for a class, it may be hard to determine. The fact pattern may look like fighting words, but it may also look like speech that advocates illegal action. So if you're writing an essay answer, my suggestion is that you argue alternatively. You make an argument under the fighting words analysis, and you make an argument under speech that advocates illegal action to determine if the speech falls in either of the two categories. Now, fighting words are directed at the person, provoking them, insulting them, directed at that person. But speech that advocates illegal action, you are encouraging the other person, encouraging that person to join you in some activity that is illegal. So that's really the distinction between the two. Now, fighting words, this analysis comes up often when we are considering hate speech. Say, for example, for one example, someone burning a KKK cross in a Black family's yard. Is that fighting words? Well, look, you know it. I have a whole clip addressing that type of speech, and I've given you the link below so you can go and you can watch it and you can consider for yourself whether that type of speech should be protected under the First Amendment or whether government should be allowed to regulate it more. Now, again, we have considered 4 traditional categories of unprotected speech: speech that advocates illegal action, fighting words, defamation, and obscenity. So you may ask, is it only those 4? Are there other potential categories of unprotected speech? Well, there have been a number of attempts to add other categories to this list. But so far, the court seems to have been reluctant to add additional categories of unprotected speech. And I also have a link at the bottom where you can hear more about some of those cases. For example, some people believe that speech such as burning an American flag should be unprotected speech, but the court has not held that. So take a look at that link to read about or to listen to and read in the text box about these other categories. Now, there is one additional category the court has added. Now, we know that obscenity is in an unprotected category, and we already talked about the test as to whether something is legally obscene or not. Well, the court has also said that there is certain speech, that there are certain depictions of children, sexual depictions of children, that for some reason may not meet the Miller test for obscenity. But the court, in a case called Ferber, has held that those depictions ought to also be in an unprotected category. So again, go to that link of the video and you can hear all about that case, where the court said it doesn't matter if the material is not obscene, because the idea is to end child pornography. So we have covered so many topics in First Amendment law. I've given you shorts on some of them, but some of them I cannot figure out how to shorten it any more than the longer clips that are available on this channel. So I encourage you to just browse through my YouTube channel and see if you may find some of the other videos of interest on some of the topics that I have not covered over the last few months as related to First Amendment or the Constitution more generally, or Civil Rights, Section 1983. I'm going to do one more clip this semester on First Amendment related to student speech, speech inside or outside the schoolhouse. After that, we're moving into the next phase of my class. My students are going to take an extended, a week-long take-home exam where they will learn more and apply what they are learning in their legal analysis. And then they are going to research and write and present and argue about position statements on current First Amendment conflicts, the First Amendment issues we are all discussing, arguing about, and fighting with one another about, not with our fists, of course, just having disagreements. So last semester, I recorded some clips where I summarized a number of my student position statements, and I've given you those links below. Some of those First Amendment conflicts are ongoing and continue. So after you watch my next clip on student speech, over the course of the next few months, if you're missing me too much, take a listen to and hear the kinds of positions my students were taking in my class and see if you agree with them or if you disagree. Learning is so important. Learning can lead us to enlightenment, and enlightenment to freedom, and freedom to justice, or at least to a taste of justice. You take care, and I'll see you soon when we will talk about student speech and the recent Supreme Court opinion. Bye.